Announce.
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Madura.
And are you Ms. Madura?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. So they have her AKA as Jan Madura, but that's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both there, it's okay, is my understanding.
Okay. Because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right. We're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madura?
What you are about to watch is not a dramatic sentencing or a shocking probation violation. It is something far more unusual and far more interesting to anyone who wants to understand how courts actually function behind the paperwork. A fraud case that should have been a routine plea hearing turns into a nearly 20-minute back and forth between a defense attorney and a judge over one specific legal question. What exactly does it mean to stipulate to evidence? And what happens when you try to cross things out on a sworn document that has already been signed? The answer to those questions is about to cause this entire plea to get rejected, reprinted, and restarted from scratch.
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Jan Madura.
All right. Thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count 1. We're proceeding on a lesser included of count 2
And what are you proceeding on?
on a Class A theft.
No objections, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500 as a Class A misdemeanor? Range of punishment is anywhere, it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. According to the plea, the state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500. They're waiving count 1. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio, and I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected toward the bottom.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Your Honor, we understand that we can address the court on the any restitution to third parties, but yes, other than that, it is our agreement.
State, is that the plea?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out all. We're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here?
Well, I am going to ask to a restitution hearing, and the fact these stipulations, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So you all will have to correct your paperwork.
Judge, if I may, We've done this before.
Right here is the core legal dispute that is about to derail this entire hearing, and it is important to understand exactly what the judge is saying, because it is more nuanced than it might sound on the surface. The defense crossed out language in the stipulations document indicating they were not agreeing that the evidence presented by the state is true and correct. The judge's problem with that is straightforward. When you cross out the stipulation that the evidence is true and correct, you are not just contesting the dollar amount to the insurance company. You are effectively saying you are not stipulating to anything at all, including the theft from the junior league that your client already paid restitution for. And without stipulating to the evidence, there is no basis for a plea. The judge is not being difficult. She is explaining that you cannot use a no contest plea as a way to have it both ways.
We are pleading no. Actually, I have on one prior plea on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provided in the law for that purpose. Having us we've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the junior league.
Well, Judge, she doesn't have to stipulate to it. No, she's pleading no contest, and so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
It was at this moment that she knew she fucked up.
No, I tell you what has been done. There has been, with regards to the indictment that's a part of it, where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented, and then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the junior league.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right,
Judge,
swap out.
if I may, we can't stipulate to the amount, so we would have at the very.
That's why you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings, and I make a decision on whether or not they owe it or not.
And Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well, that's where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid, or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that, so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things. And it's going to be, we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this. If she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league, because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I will hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever. That's like on or about whatever. I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then
amount.
you all need to change your paper.
And Your Honor, I know, to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct.
And right there is the moment this hearing reaches its breaking point. After going back and forth for several minutes about what can and cannot be crossed out on a stipulations document, the judge stops the entire proceeding and says plainly that she is not accepting this plea. The paperwork needs to be completely redone, not corrected, not amended with handwritten notes, reprinted entirely and resworn by the clerk, because the version that exists right now has been altered after being sworn to and is no longer a valid sworn document. What started as a dispute about a specific dollar amount to an insurance company has now sent both attorneys back to square one with a full reprint required before this hearing can proceed at all.
The judge has the evidence, and the judge can look at that and decide that they find those documents credible and find that they are true.
I can't do any of that if y'all are not stipulating to anything. Then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you accept if we just simply put on that we do not stipulate to the final amount?
Y'all do the paperwork, and if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the thing. I haven't read any of the evidence, so I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. This argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even.
When the case comes back, the judge immediately identifies that the new paperwork still has a problem. The defense wrote that they are contesting the total amount owed for restitution. But the judge points out that this language is too broad because the total amount includes the junior league payment that both sides already agreed on and that has already been paid. You cannot contest a total that includes an amount you just said you are not contesting. The judge is asking a simple question. Why is it so difficult to write specifically that the contested amount is what is owed to Berkshire Hathaway and Visa and nothing else? That level of precision is exactly what a sworn legal document requires, and the defense attorney keeps writing language that is broader than what she actually means. What do you think happens to a case when the paperwork keeps saying something slightly different from what the attorney intends?
We haven't got to that point yet because nobody stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount, so we don't want to stipulate to that. So we'll change the document to say that, and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer you're not, because y'all agreed that she owed the amount to the junior league. Am I right?
Right.
So that's not contested.
Right.
So
Judge,
if you want to put that in there, you need to put specifically what you're contesting. If you're contesting the insurance company, then you should put the insurance company in there. Otherwise, you're saying you're contesting
Judge, may I address it?
Sure.
I'm the one doing this, not
Okay.
Chandler. So, Judge, what we're contesting is just the final total amount that are in the documents that are contained in State's Exhibit 1. And so that's what I'm trying to put on there, that we're contesting the total amount that they're saying is owed.
So you're contesting the amount that they're saying is owed to Berkshire Hathaway and Visa?
Yes, indirectly. I mean, in the documents, Judge, in the State's Exhibit, it has that she owes that the total amount for the funds that were taken were $11,000 something. Okay. We agreed to make a payment of the $1,077.01 up front, but we have never, and we don't want to in the paperwork, to stipulate that the $11,000 number that's in the State's Exhibit documents is a correct number. We believe it's lower. So that's the only issue. And Judge, and the reason why I want to have this in the paperwork is because if we're requesting that you not order a restitution hearing and let the third parties handle that on the civil side, where they can get accountants and they can really dig into that. And so if we stipulate to the true and correct nature of all of the state's exhibits, that includes that 11,000 number, and on the civil side, then there's nothing for them to, have accountants come in and.
So this is what I'm telling you all. When you say you're not stipulating, you're stipulating to everything but the amount, you're including the amount to the junior league in that. If you want to put in there
Okay, I can put
something else to address that, you can put that in there. But when you all say you're not stipulating to any amount, then she's not even stipulating to the junior league amount.
Okay. We can put in there to third parties.
Well, the junior league is a third party.
Well, the junior league is the complainant. They're not a third party.
What I'm telling you is the parties are the state and the defense.
Right.
Well, your client, the state and your client. The junior league technically is a third party. So whatever is in there that you all are not stipulating to, which it appears to the court from your plea bargain agreement, the only thing you're not stipulating to is the amount to Berkshire and the amount to Visa.
Yes, Your Honor.
Is that correct?
Yes.
So
And
why
that's
is
below
it?
the line anyway.
So why is it hard to put in there? We are not stipulating to any amount owed to Berkshire or Visa. Why can't that be added if that's the total amount?
I can do that, Judge.
Okay. Thank you.
Thanks, Judge.
Do you want us to print this out again, or can I just change the language?
You'll have to write it in there and then have her re-sworn by the clerk. All right. Anyone else ready? All right. Court is calling 2024 CR 011624 State versus Jan Madura. Could I have parties re-announce?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Maduro.
All right. And now you, Ms. Madura?
Yes.
All right. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right. According to the plea, the state is waiving count one, proceeding on the lesser included offense of theft, $750 to $2,500 under count two. They're recommending deferred adjudication. There's restitution of $1,077.01 to the Junior League of San Antonio through the DA's office, and that has been paid. Is that correct?
Correct, Your Honor.
Did you understand that to be the plea?
Yes, Your Honor.
State?
That's right, Your Honor.
Defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
After nearly the entire hearing being consumed by a dispute over stipulation language, the judge finally accepted a corrected plea and deferred the guilt finding. But the restitution question to Berkshire Hathaway and Visa is still unresolved and is now being set for a full restitution hearing in 45 days. The defense immediately asked the judge to skip that hearing entirely and send the third-party restitution question to civil court instead. And the judge said no without hesitation. The state's argument is clear. The defendant received a benefit she cannot keep. And until that amount is determined properly by this court, the sentencing on this case cannot be completed.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be restitution of Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Deferred adjudication granted on a lesser included theft charge. Restitution of $1,771 to the Junior League already paid. A restitution hearing set for December 11th to determine what is owed to Berkshire Hathaway and Visa. And a hearing that consumed almost 20 minutes of court time because of a stipulation document that kept saying something slightly broader than what the defense actually meant. The judge handled every round of that exchange with patience and precision. And in the end, the message was simple. If you want to contest a specific amount, write down that specific amount and nothing else. Follow for more real courtroom breakdowns.
Then to the lesser included offense under count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
For Exhibit 1 with all attachments.
Any objection?
No objections, Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
All right, after viewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. All right, with regards to the amount that's outside your agreement, we'll come back for a hearing, and at that time, I'll sentence.
Okay.
All right, Ms. Ferguson, I need a reset date, and this is just for restitution.
And Judge, are we going to have a full restitution hearing? If so, we're going to have to get a forensic accountant, I'm not an accountant, to go through all of the documents and bank records to prepare for that hearing. Your Honor, I would respectfully request if you would not order restitution or not make a decision and not have a hearing and let them handle that on the civil side in the civil courts.
Yeah, I'm not going to do that.
If I may respond briefly.
Yes.
Just the state's theory that amount be assessed as restitution is that is an amount the defendant received the benefit of. She can't keep.
I'm sorry?
She can't keep that benefit.
Okay. All right, we'll set it for a restitution hearing. Norma, I need a reset date for a restitution hearing.
And Judge,
You're out 45 days.
just to make it clear, we're not requesting that she keep anything. We are requesting that we get to the correct amount.
Okay. All right, we'll be back on December 11th. Once you sign the